Come on up whenever you're ready. May it please the court. My name is Robert Anthony. I represent the appellants, and you got it right. Judge Silverman is Paglialonga. That's one of the 5 condominium owners. I think you're being generous with how I pronounced it, but thank you. I think you did pretty well. I would like to reserve 5 minutes for rebuttal. Thank you. So I represent the 5 condominium owners. This is a case between the condominium owners and Crescent Beach Club, which is a condominium association. The first issue on appeal, it's a very narrow issue. It's if a party who sues you announces that they no longer believe that there's a dispute, does the initial dispute just go away? Because this is a case that Crescent Beach Club sued the 5 condominium owners. They sued us in arbitration under 718.1255. That's the condominium statute. That was the initial dispute between the parties. Crescent Beach Club sued the 5 condominium owners. That initial dispute had 2 main parts. First, the association contended that these 5 owners were violating a 14-day minimum term provision in the declaration. Second, they said they were advertising and informing others that they could rent the unit for less than 14 days, and that the advertising confirmed this illegal renting. So under the Department of Business and Professional Regulation, when you file this mandatory non-binding arbitration petition, and they filed 5 separate petitions against these 5 condominium owners, you can be ordered to go to mediation at the DBPR level. That happened. All right, there was an impasse at mediation. So of course, impasse, there was no resolution at that mediation level. So what happens next? Under 718.1255, what happens next is that the arbitration case is dismissed. And then you have to get to the statute of this narrow first issue. The arbitration case is dismissed. What rights do these condominium owners have to have a determination on the merits of those 5 cases? What?
Am I correct, Mr. Anthony?
Yes.
The trial court is being asked to opine on what would have happened had the case proceeded to arbitration.
The trial, the way that you phrased it, I think is accurate, because the trial court is being asked to conduct a trial de novo, which would be what would have happened for those 5 cases before the DBPR.
Why is that not asking for advisory opinions when the parties appear to have resolved these issues?
Right. When the appear to is critical, right? This was on a motion for summary judgment. The evidence was that there was no resolution. Now, the association contends there was a resolution, that there was no present dispute. So the issue is, can that initial dispute be resolved? And the critical part about it is not asking for an advisory opinion, because the statute says that upon dismissal, either party has the right to have the case heard in a court of competent jurisdiction and to seek the attorney's fees that they incurred at the arbitration and at the mediation. Both of those things, the statute specifically says that you're allowed to pursue.
But there still needs to be, now that we're in trial court, there still needs to be an active dispute between the litigants.
Well, the active dispute is the arbitration petition that accused the 5 owners of violating the 14-day minimum term provision and by advertising that people could stay for less than 14 days.
To my mind, what you've just done is you've just dovetailed the statute's language that says either party may institute a suit in a court of competent jurisdiction. Just dovetail that into your separate issue on appeal, which is that the statute gives you an independent cause of action. Because there is no standalone cause of action in Florida law that says you can have a trial court determine what an arbitrator would have done had an arbitration that had been dismissed gone forward. There's no such a standalone cause of action, right?
There's no standalone cause of action under 718-1255. It's the procedure of the condition precedent to go to court. The cause of action was breach of contract. CBC sued the 5 owners for breach of contract, breach of the declaration. That's the cause of action. But we were the defendants in the arbitration case.
After the mediation reaches impasse, the arbitration is dismissed, but the parties continue to resolve the underlying issues as to the nature of the advertising and the term of the lease. By the time they get to the trial court, I'll use the word whatever underlies the arbitration or the mediation has now been resolved. So here's my active case or controversy.
It has not been resolved in the eyes of the 5 condominium owners, all right, because there's never been a settlement agreement. There's never been a payment of the attorney's fees that were incurred at the arbitration level, which the statute specifically says you're entitled to seek in the subsequent litigation.
In a suit, you have to file a suit. Your suit here was a deck action, correct?
It's a declaratory judgment action because we couldn't sue them for breach of contract. You know, the breach of contract was what they sued us for.
So you're for better or for worse, you're stuck in the law of deck actions. And the law of deck actions is you have to have a live controversy.
Right. And
It can't just be an advisory opinion,
that's true.
which is what Judge Rose was touching on.
Right. And we're not saying that this was seeking an advisory opinion. We're saying we're seeking the opinion of, did we violate 14-day minimum term provision for allowing people to stay less than 14 days, and by advertising that people could stay for less than 14 days, as long as they signed a 14-day minimum term lease.
But if the association has conceded that we've seen the light, that is not a violation of the declaration, then how do you, cabin for a moment, just put it aside, trying to recover your attorney's fees, put that aside for just a moment. What legal rights get vindicated? What other relief do you get? How does your client been any better off when the association has said, yeah, that advertising is okay, we're now singing from the same hymnal on that?
Well, the way that they say it in their answer,
It's that use of the present tense. I get it. I get it.
Right. The way that they say it is, okay, we don't have a present problem with what you're doing,
but you may in the future.
And not only may in the future, they don't provide any specificity about what is it that they don't have a problem with, because the declaration doesn't allow them to even have any say about advertising. All right. And it's important that the 5 condominium owners can advertise however they want to advertise, because there's no restrictions on advertising, and the association is bound by the declaration. You know, they're allowed to require a 14-day minimum term lease. So the critical issue here relates to trial de novo and the statute that says this mandatory non-binding arbitration procedure is not intended to eliminate or the statute says is not intended to avoid your right to a trial de novo. This is critical because 718-1255 was a legislative attempt at alternative dispute resolution because associations are more powerful than the owners generally. That's what they say.
Don't we have to assume that when you're seeking a trial de novo, you are dissatisfied with the result announced by the arbitrator? And we have no result by an arbitrator.
right, you're dealing with subsection K.
Yeah.
We're dealing with subsection H. And subsection H says if there's a mediation impasse, this is what you have to do on subsection H. It says, if the parties don't agree, then you get dismissed, and either party may institute a suit in a court of competent jurisdiction. Either party. Now, the beginning of the section says nothing in this provision shall be construed to foreclose the parties from proceeding in a trial de novo. All right, and trial.
Suppose you ask for a trial de novo and you move forward and the parties resolve the case. That's the end of the story, right?
If they resolve the case in the circuit court case,
Okay.
but they didn't, there was no settlement agreement. There's claim for, and again, it's claim for attorney's fees back at the arbitration level and at the circuit court level. But if you read these statutes, the statute's supposed to preserve your right to be heard, its case to be heard. Its case was the case they sued us over. Its case is that case in the arbitration, those 5 different cases. That's the case. It's not an advice.
As I'm saying, the plaintiff is the master of the complaint. If the plaintiff doesn't want to go forward with the plaintiff's case, you as the defendant can't make them. So I think your case here has to rise and fall in the deck action.
Well,
You keep trying to bring it back to the breach of contract action, but they were the plaintiff there.
Yeah, but the statute says either party.
If the statute says you may institute a suit in a court of competent jurisdiction, that party was that you just set up here. You're not seeking a breach of contract action, right?
We're seeking a determination that the breach of contract action was wrong on the merits. That's what we're seeking. We're seeking a determination that those 5 condominium arbitration cases, that the breach of contract and the request for injunctive relief, they were requesting that we not inform others.
I think your better argument is, instead of keep trying to tie it back to the cause of action that they brought, which has gone by the wayside, to me, it makes more sense for you to argue along the lines of, we need a declaration that our advertising practice and our rental practice at that time was okay under the declaration, because we're still in doubt about our rights based upon the way that they've answered this sovereign complaint. We would like to go back to advertising the way we used to and renting the way we used to, but we're not sure that they're not going to just sue us again. To me, that's a more cogent argument about what a deck action would be.
Right, but that's what the amended complaint says. The amended
Right, but you keep arguing that it's a breach of contract.
No, but the amended complaint says, all right, that our leasing practices should not be restricted. All right, and the evidence is that our leasing practices never changed, that not before or not after the arbitration case, that our leasing practices, which includes the advertising, that you can stay for less than 14 days. Now, to me, the critical issue is this statutory framework. That's the start of the litigation process, this statutory framework, and it provides nothing is to prevent you from having a trial de novo. So that's where we get, and I know I only have 2 minutes left. I want to get to the notice of supplemental authority, which is the Allison versus Carrollwood case that just was decided 2 weeks ago, and Judge Silberman wrote the deciding opinion there. In the Allison case that was decided, it was a trial de novo after an arbitration decision, right? After an arbitration decision, and it's non-binding, all right? So you're able to go and have the matter resolved in a court. It's the same thing, the respondent at the arbitration level, they had to go sue, declaratory judgment. There was no issue. That was the way you do it, because you were the one being sued. You're not bringing the cause of action. You're defending the cause of action.
The distinction with Allison, though, is that there was a trial de novo of issues that were decided in the arbitration. So they were still susceptible of being reviewed and considered in the trial de novo, correct?
That's true, that because they had an actual arbitrator's decision, but it was non-binding, right? So the same principle should apply, that the trial de novo is required under the statutory framework. The trial de novo is required. It's not discretionary. You're entitled to a trial de novo of the issues that were brought in those 5 arbitration cases. in Allison, the court defined what's a trial de novo. The trial de novo is a trial of the entire case in the circuit court. The entire case that was in the arbitration
It was
case.
a deck action. Allison was a deck action.
It was a deck action, and so was ours. We want a trial of the entire case that was in the arbitration cases, just like they did. They wanted a trial of the entire case in the circuit court from what was the non-binding arbitrator's decisions in the arbitration case. And the definition of the trial de novo that you put in your opinion was the trial de novo determines liability. Okay, it determines liability. And what's the liability? The liability is from what was asserted in the arbitration case. I know I have less than 5 minutes. I'd like to reserve for rebuttal. Thank you.
Thank you.
Thank you, Mayor. Please the court. I'm Brian Hull on behalf of the Appalachia Crescent Beach Club at Sand Key Condominium Association, Inc. And this appeal really comes down to two simple questions. Number one is, did the trial court properly decline to issue a declaratory judgment to decide a past dispute over who would have prevailed in the arbitration? And number two, did the trial court correctly decide that section 718.1255 does not create a new independent cause of action? And on both of those issues, the trial court's summary judgment order got it exactly right. In this case, what the unit owners asked the court to do was issue a declaratory judgment that decided the request for relief that had been made in the prior arbitration petitions. And those petitions addressed past leasing practices under former leasing documents. And those practices and leasing documents all changed at the time that arbitration was dismissed. This suit came 8 months later. This is not a situation, not a case where the owners claim to have lost out on any rental income or suffered any damages because of past instances where the association refused to approve their leases, for example. This is a case where the owner simply sought a declaratory judgment about whether their past leasing under former leasing documents would have been in violation of the declaration.
Mr. Hall, let me ask a question. In terms of the mediation, which was at an impasse, had your client at that point in time said, you know what, we're wrong, we're not reading it the right way, we're going to change it, so you're all okay? Would they be without remedy to the extent they incurred fees and costs in the arbitration and mediation?
If that had been the scenario, is your question? If our client midstream in the middle of the arbitration.
No, after the impasse.
Okay.
Your client, excuse me, after the impasse, if your client says, you know what, we get it now, we think we blew it, you don't need to file a trial de novo, we're not going to enforce it in this way anymore, would they be without a remedy?
And in your scenario, setting aside any changes that any parties
Right.
made, same set of facts, had
No,
the facts been.
your client just says, we're wrong,
Yes,
we now see it.
sure. And in that scenario, I would say that they are not entitled to fees under the statute. Examining the language of the language of section 718.1255 in a scenario where the arbitration is dismissed as a result of an impasse at mediation, the remedy is for the owner to file the suit, pursue the litigation, and then at that point, at the conclusion of that litigation, they're entitled to seek their fees for both the litigation and for the arbitration and mediation. And in your scenario, I think it would be a situation where they wouldn't be able to pursue that claim because yet again, there would not be a present dispute. So the legislature didn't set this up in a way that they would be entitled to fees. The language of the statute only overrides the American rule to allow a fee award where the arbitrator renders a decision on the merits and that the fee award goes to the party who prevailed in the arbitration, or in the situation where there's a trial de novo, which again, trial de novo, as you've observed, comes up only after there's been an arbitration award. And under the statute, fees can be awarded
Well,
there.
under the statute, if it's dismissed, any party can, so you don't necessarily have to have an award. You could have a dismissal of the arbitration under the statute and have a trial de novo. You still got to fix, I think your point though, that it still has to be under a recognized cause of action. I get that, but there can be a dismissal of the arbitration. You can still seek a trial de novo. Either party could, right? Under the text of the statute.
Under subsection 4L, I believe a trial de novo comes after there has been an award, and so they're asking for a trial de novo to basically re-examine the issues that were decided in the arbitration.
I think it's might have been H is what I was looking at right there.
Subsection H is the one where there's an impasse at mediation.
Right, and then, which then contemplates that, and then says, hold on.
Yes, no, I think I understand your point. Yes, under subsection H, could a party sue if, say, the case was dismissed, the arbitration was dismissed without an impasse at mediation? The way subsection H is worded, it allows either party to institute a suit in a court of competent jurisdiction. That clause follows the phrase, the arbitrator shall enter an order of dismissal. Would they be able to pursue an action in court if the dismissal came not as a result of an impasse at mediation? I don't know that they could under subsection H. I don't think the legislature had contemplated that specific situation where the case was just outright dismissed without an impasse at mediation.
But you would still have to satisfy the constitutional requirement of a live controversy.
Absolutely. At any point in time, if you want to bring that case in court, you have to have a live controversy, no matter where the parties stay.
So let me follow up on my question just a little bit differently. If after the impasse, and I know this is a hypothetical, so work with me on this. If after the impasse, your client says, we misread it, we're not going to do anything. And the other side says, well, wait a second, you took us to an arbitration that was frivolous. We think you had no basis for it, and you've now conceded that you read it wrong. Under the declaration and the articles and the restrictions, the covenants and so forth, would they potentially have some sort of breach of contract action? And if the answer is maybe yes, maybe no, we don't know in this case, but let's assume the answer is yes, they might. They'd still have to go back to arbitration at that point on this new claim.
If there's a new claim and it fits within the meaning of a dispute under section 718-1255, then yes, that would have to go back through arbitration. I don't know if under that scenario, that particular issue would meet the standard of a dispute within the meaning of the statute.
Well, or a dispute within the meaning of the restrictions as well, the governing document.
Sure.
Okay.
Sure, but in this case, we're dealing with just two causes of action, the declaratory judgment action and then the suit on 1255. And based on just the allegations that were in front of the court here.
And there was evidence, if I recall correctly, there was information presented to the trial court that the parties together figured out a solution that would work for them.
Yes, Your Honor. They did work together. The association had presented the unit owners with some changes that they were proposing to their, I believe, rules and regulations, as well as their leasing materials. And in the association's view, all of that worked together to resolve their concerns, to resolve their issues with the unit owners' leasing practices. It required them to identify, are these people going to be staying during the entire term of their lease, or are they going to be doing these shortened occupancies? When are they going to be on the property? When are they coming? When are they leaving? Those sorts of things to address the association's concerns about security and other issues like that. So yes, the parties did work together to an extent, but ultimately the association came up with new leasing documents that addressed all of those issues. And so then the question becomes, under these new leasing documents, is there any sort of violation? And the association has always taken the position that there is violation now that they've developed these new documents, now that they have implemented these new rules and regulations that make very clear to the new tenants that they have the ability to stay the entire 14 days, even if they had made arrangements with the unit owners that they were only going to stay a shorter time. The declaration itself gives them the right to stay there for the full term. And now the tenants know that.
Putting aside the advertising issue, was there any dispute that the homeowners were in fact renting units more than 26 times a year?
I think that that was still an open issue. That was still an open question. I believe that on summary judgment, I think that all that you had in the form of deposition testimony was just an expressed uncertainty. I don't think we came up with, in opposition to their summary judgment, specific instances of where that occurred.
Okay, so this is kind of goes to that, the way that the framing of there is not presently a controversy. Would you agree or disagree that if there was a dispute about whether or not any units had been rented more than 26 times a year, or there was an overlap in rental periods, that would be subject right for declaratory judgment?
If there were facts where we thought that they were indeed,
In fact, it's an allegation in the deck action. It's paragraph 29. Plaintiff units are not now and have never been rented more than 26 times per year. No lease's rental term for a given unit overlaps with the term of another lease for the same unit. Homeowner association denied that allegation. Why isn't that still right for determination as a deck action? Because if that happened, put it this way, the way things stand right now, there's no reason why the homeowner association could not come back and say, hey, you know, we've now found some information, and we think that you were in violation of this provision, and we want to go forward with that in arbitration again.
I think our position would be, if they were indeed leasing more than 26 times a year, then that would be something that we would be litigating. Yes.
Yeah. So why is that? You're not really telling me anything about the state of the case, though, deck action, because the deck action put that issue before the court. And that issue you just confirmed really isn't resolved.
They haven't asked for permission to do that. Okay, their deck action says.
Try my question, Joel. My question was, is there controversy about whether or not that has happened? And you're not telling me that there isn't a controversy about it. And that issue was put before the court of the deck action.
I think that their issue, they have consistently said that they are not doing that, and we said in response, we don't know if they're doing that or not.
You denied the allegation, so that's a controversy, and it directly, I mean, it's point blank right on a restriction in the decks. So
But
why do we have deck action on that? Have the court figure it out.
well, that's not a present controversy, because we're dealing with the new leasing documents, and are they in violation of the new leasing documents with their current leasing practices? We're not talking about the old leasing practices. We're not talking about the old leasing documents. What we're talking about is on the facts alleged in the complaint, are they in violation of the declaration? And we have never taken the position that these new practices are in violation of the declaration.
So what you're saying is what's happened has happened, that's in the past, and the association would not seek to litigate those past issues about if in fact the units were rented more than 26 times. That's water under the bridge. You all would not bring that up again in a subsequent one.
There's no need to litigate that issue.
So yes.
Now, if it comes out, if the association learns
Is that a
in the
yes or no?
we have no need to litigate that issue.
That just tells me that there is a need for declarations, Joel.
And maybe I'm missing your point. I don't
My
know.
point is
I don't
that
see
there
what.
was an issue brought before the circuit court in a deck action that we have not and have never and are not now. We've never done it in the past, rented these units more than 26 times per year or had an overlap.
Mhm.
And you're not willing to say today whether or not that there's no controversy about that. And if that's a controversy, then the court had jurisdiction to decide it.
We are not challenging whether or not they were. I don't think that's an issue, whether or not they were in there for 14 days or not. They say they weren't. We said that's
You
not an
denied
issue.
it.
That's not a problem.
You didn't, but you denied it in your answer. At least I should say the homeowner association denied it in their answer.
Because we didn't have the information whether or not they were indeed signing leases that put people in there more than 26 times per year.
And as you stand here today, on behalf of your client, you can't tell me whether or not that past issue, like is resolved or not? All you've said is basically we don't anticipate bringing arbitration at this time, which does nothing to assuage the concerns that the homeowners association might have, which is that we find ourselves in arbitration again about these past practices.
Well, they have not asked to lease for more than 26 times per year. They're not asking to do that. If they were asking to do that, then that would be a situation. Or if they were violating the term that, if they were putting people in there more than 26 times per year, then yes, that would be an issue. But the way they've alleged it is that there are not people in there more than 26 times a year. They've never done that. And if that's indeed what they did, we don't have a problem with that. And we have created these new documents that now allow us to address our concerns, which was the fact that they were putting these people in there for shorter occupancy.
So if that happened in the past, that would be water under the bridge, because now you've got the new documents in place.
Right.
Okay.
Now we have the new documents in place. With respect to the statute, and whether or not it creates a separate cause of action, I think the legislature used very clear, unmistakable language that it's a condition precedent to suit, did not create a brand new cause of action, and that's what the trial court correctly decided. As far as a trial de novo, that issue just does not apply without that arbitration award, without the arbitration decision. I would say that the type of suit that has been filed here is not what the legislature had in mind when it enacted Chapter 718.1255. The unit owners were not entitled to a declaratory judgment to decide a past dispute or decide who would have won at the arbitration. And even if a declaratory judgment had been appropriate, Section 718.1255 still would not allow for an award of attorney's fees in that situation. The trial court correctly decided that this case does not involve a present dispute worthy of a declaratory judgment, and that Section 718.1255 did not create a brand new cause of action. The final summary judgment should be affirmed.
Very good, thank you.
May it please the court. The question, Judge Silverman, that you asked is a good question as far as, are we without a remedy? And this is a legislative statute for alternative dispute resolution. It's not to deny you access to the courts. You're supposed to have a remedy. Otherwise, it's an alternative dispute, like we said in our brief, alternative dispute non-resolution, right? We should have a remedy in court when we are sued by the association and they seek attorney's fees in those 5 arbitration cases under 718.303. They seek attorney's fees under the condominium statute, and then they just walk away. It is analogous to a voluntary dismissal. And with everything else the same, if they had done that in court, then the 5 condominium owners would have been entitled to their attorney's fees. So this statute, though, says that you're entitled to seek your fees in the subsequent litigation. So the trial de novo introductory language in 718.1255.4, the introductory language says nothing in this provision is to foreclose you from having a trial de novo. Now, in subsection H, it doesn't use the phrase trial de novo. Agreed, it doesn't. Subsection K uses the phrase trial de novo. Subsection H uses the phrase subsequent litigation. But that introductory clause, it means something. It means nothing in this provision should prevent you from having a trial de novo. And the association, Judge Lucas, the association, they denied almost everything that we alleged in the First Amendment complaint. They also denied, that we were not in violation during the time of the 5 arbitrations. They denied that too. And they denied virtually everything. They didn't admit much of anything. So at his deposition, when pressed, hasn't this been resolved? Mr. Paglialonga said, not at all. This is on pages 2377 through 2379 in the record. Not at all. There was no resolution. It was never resolved. And then later in his testimony, 2374 and then 2391, he says our leasing practices didn't change. And this is critical because the old leasing documents, the very first page of the old leasing documents, it says minimum lease term 2 weeks. It says it right on the leases. We've never had leases denied before the arbitrations, after the arbitrations. The leases have always been approved. There's never been a denial. So now they're continuing to approve them, but they have no right. They didn't have a right then. They don't have a right now. They don't have a right to challenge our advertising. People can stay for 3 days, 5 days, 7 days. And that's what the Green versus Grider case confirmed. This is the second DCA case. And the reasonable inference, of course, this is summary judgment. The reasonable inference is at mediation, when we brought up the Green versus Grider case, they realized, uh-oh, we're wrong. You know, they can tell people they can stay for less. But then they say that we admitted or that we cooperated with them. But we cooperated with them because they have the absolute right to put in the leasing package when people come, when people go. What they don't have the right to do is challenge our advertising. We can advertise. And if you want to look at the evidence that they cite for cooperation is emails from 3 of these condominium owners. And it's in the record at 2266 through 2270. Those 5 emails are chastising the association for having brought this case in the first place. Right? One of those emails from Mrs. Paglialonga says we've never rented the unit more than 16 times last year. Not, 26 would be our cap. We rented it maybe 20 or 16 times last year. Mr. LeMessurier and Ms. Stockton saying we've been falsely accused. Clearly there's been no violations. Okay, but we've still not had a determination that there's been no violations. All right, we deserve that determination. They can stipulate to it in the circuit court case that there was no violations and there are no violations. And then we get our award of attorney's fees. And that's the critical issue really, is the statutory framework. And in our brief, we talk about access to the courts. A statutory framework of alternative dispute resolution is not supposed to deny you access to the court. If somebody sues you, you should have the right to go to court and have it resolved. What's happened here, the trial court on summary judgment, despite evidence that there had been no resolution, the trial court says, I don't have to determine, all right, because I'm going to find that there was a resolution.
Anthony, we are at the end of your rebuttal. So thank you both very
Thank
much.
you very much.
We will take a 10-minute recess and then we will come back for the last case on the docket.
All rise. Stand in recess for 10 minutes. Thank you.
All right. Thank you.
Yeah, nice to meet you too. Only seen you on Zoom, I guess.
I guess, yeah.